Welcome back to our channel. Now we are discussing a waterfall mechanism under IBC, section 53. We'll also discuss the evolution of priority payments from Companies Act to IBC. Under Companies Act 1956, there was no codified structure for preferential treatment of creditors in corporate liquidation. While section 529 extended certain insolvency provisions, there was no detailed priority scheme. So recognizing the rights of workers, section 529A and 530 were inserted via 1985 amendment, introducing overriding preferential payments and subordinate preferential payments. So these have now evolved into section 326 and 327 of Companies Act 2013. However, the true game changer was IBC, Insolvency and Bankruptcy Code 2016, with the codified a detailed waterfall mechanism under section 53 for distribution of liquidation proceeds. Section 53 of IBC, this is the statutory waterfall mechanism. Under section 53, subsection 1, is a clearly explained the liquidation proceeds distribution. Priority wise, the first, insolvency resolution process and liquidation cost, and then secured creditors who are relinquished their security and workmen dues paribasu for 24 months preceding liquidation commencement. Workmen dues preceding 24 months preceding liquidation commencement date. And third category, wages to employees. These employees other than workmen for 12 months preceding commencement. Next, distribution priority, unsecured financial creditors. And then government dues. Government dues 2 years preceding commencement, and the remaining security creditors who did not relinquish security. Who has relinquished security, they comes under second priority. Then who not relinquished their security, so they come along with the government dues. Then remaining debts and dues, after that preference shareholders. If anything remaining, this will go to equity shareholders and partners. This is the priority list under section 53 of IBC. Here, secured creditors have an option under section 52 to enforce their security interest outside the liquidation, because they are secured, so they can enforce their security without coming into the liquidation. However, proportionate insolvency cost and workmen dues must be still deducted from the proceeds. We'll go to section 36, exclusion of employee welfare funds. Because the section 36(4)(a)(3) of IBC explicitly excludes the employee-related welfare funds like gratuity, provident fund, pension. So these are all excluded from the liquidation assets. This ensures that such dues are fully protected and kept outside the reach of other creditors. So this strengthens the social security framework within corporate insolvency. Now, the interesting topic is inter se arrangements of secured creditors. This is the biggest legal gray area, is the treatment of inter se rights of secured creditors. We'll see the landmark judgments in ICICI Bank Limited, Sidco Leathers Limited. The Supreme Court upheld contractual inter se arrangements among secured creditors. However, in another case, Technology Development Board versus Anil Goyal liquidator, the NCLAT held that once the security is relinquished, section 53 overrides any such contractual arrangements. So this situation has created little uncertainty with some secured creditors opting for surfacing rather than proceeding under IBC liquidation. And operational creditors at the bottom of the waterfall. Operational creditors such as vendors, service providers, MSMEs, they rank below financial creditors under Section 53. Supreme Court in the landmark Swiss Ribbon versus Union of India upheld this differential treatment, reasoning that operational creditors lack financial exposure and risk evaluation capability. In NCC Limited versus Golden Jubilee Hotels Private Limited, the NCLAT upheld classification among different operational creditors, stating that such classification is valid as long as it meets Section 30, subsection 2 conditions, and it is based on the commercial wisdom of COC. So there is a growing concept that operational creditors should be guaranteed a minimum payout percentage in a resolution plans, ensuring fairness and sustainability for small vendors. We also see the comparative global landscape, what other countries are doing. In USA, employee wages and administrative expenses rank ahead of secured creditors. In UK, insolvency costs, wages, pension dues come before secured claims. Singapore, similar to India, with statutory protection for every employee, almost similar to India, statutory protection for employee dues. In France, strong pro-worker stance, employee dues take priority. In Germany, insolvency cost, then secured creditor, then general creditors. UNCITRAL model says it recommends flexible models to protect vulnerable stakeholders. So while India's framework is a balanced on paper, available data from certain cases shows that the operational creditors have, in some instances, recovered less than 5% of their admitted claims. So the reforms are needed. Calculating the waterfall despite codification, India's current waterfall structure under Section 53 requires recognizing valid inter se arrangements. If secured creditors have valid pre-insolvency agreements regarding priority, so the IBC should allow enforcement of those terms even after security is relinquished. And minimum a threshold for operational creditors. Introduce a mandatory minimum a recovery percentage, like 10% of financial creditors get, to safeguard MSMEs and service providers from being wiped out. We have two channels, RR Corporates and other channel RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of our latest videos. Thank you.